Good afternoon, everyone, and thank you so much for joining our webinar, HIPAA Lockdown, our one-hour guide to PHI best practice. My name is Amanda, and Larry Gragine, our ERISA attorney, will be your presenter today. I'm going to be keeping the webinar on mute since we have over 100 people registered today, and we'd like to keep the background noise to a minimum. But if you have any questions, please just type them in the question box below, and I will either ask them periodically or at the end of the webinar. Our next webinar will be in 2 weeks on July 25th, again at 1 p.m., and we'll be covering MIWAs. For now, let's get into the webinar.
MIWAs, what are those?
We'll be covering multiple employer welfare agreements. Before we get into the webinar, I just wanted to run a quick poll because some folks aren't exactly clear who is subject to a DOL HIPAA audit. So if you could just select on your screen which you think are subject and hit submit, and then we'll share. Almost everyone has voted. I'm going to give it up to a full minute. And then we'll move on. All right, so I'm going to close the poll. So most of you are correct. Everybody here is subject to a DOL HIPAA audit. What a lot of folks don't know is that any employer who provides health insurance likely handles PHI, which is protected health information, and Larry will go into that more later. A lot of employers think that they aren't subject to HIPAA audits because they think they don't handle PHI, when the truth is if you provide health insurance, you do. So Larry is going to go into how to prepare for an audit. Just a little bit about Larry. He's our ERISA attorney practicing exclusively in the field of employee benefits. He has experience in dealing with qualified plans, health and welfare, fringe benefits, and executive compensation areas, and he has more than 35 years of experience in employee benefit law. He was also an adjunct faculty member of the John Marshall Law School's LLM program in employee benefits and at the Valparaiso University School of Law. Valparaiso, thank you. He has a BA in History and Political Science from Indiana University and a JD degree from Valparaiso University School of Law, an LLM degree in tax from Boston University School of Law. He's a member of Indiana and Illinois bars. With that, Larry, take it away.
Thank you. There's a lot of misnomers, as Amanda indicated, in regard to HIPAA privacy. The biggest misnomer is that I don't handle PHI, I have an insured plan. 9 times out of 10 when I'm talking about employers, to employers about HIPAA, I question them, and 9 times out of 10 they do handle PHI. Now basically PHI, protected health information, is basically enrollment and claims information, and most employers, especially their HR departments, will assist employees in enrollment and in filing claims, doing appeals. So there's all kinds of ways that employers can handle PHI. Now, once you handle PHI, the problem is that you've entered the wonderful world of HIPAA privacy, and in order to do that, either you have to get individually an authorization from each employee, or you adopt HIPAA privacy and procedures. What I'm going to be doing today is kind of introduce this to you, indicate what you have to do to comply, one of the ramifications behind complying with HIPAA privacy, what happens if you have a breach, which is extremely important. And Amanda was talking about audits, and a division of HHS is now conducting audits, and they're very sneaky about these conducting audits because what they'll do is they'll first introduce themselves through an email. So you may get an email from the Center for Civil Rights thinking it's either an advertisement or something, one of these governmental emails. Basically, it is from the government, but is basically indicating to you that they want information from you in regard to a DOL, a HHS audit. So I'll be talking about that and look for that, because what they were doing in these audits, they were doing hospitals and the doctor practices. Now they've gone down to the average employer. In my experience in working with employers, very few employers actually understand and know how to deal with HIPAA privacy, and they don't do a very good job at it. So health plans under HIPAA privacy, and again, HIPAA privacy has been around since 2003. So this is something, and it's been changed a number of times. There's at least 2 to 3 sets of regulations, and it's changed over time. So health plans are required to protect and safeguard a participant's or covered dependents' personal health information from impermissible use and disclosure, and they must obtain a patient's or participant's consent for certain uses and disclosures. So what is required to protect information? I will tell you what you have to do to comply. And there's a number of different steps you have to make. What information has to be protected, and again, I will indicate to you what we're looking at here, and then I will expand on that to indicate what steps must a health plan and employer do to comply. Now, these HIPAA privacy rules also apply to any vendor that services your health plan, which means your broker, your TPA. It could mean your IT department, IT vendor. So anyone who has access to protected health information from your health plan basically has to take steps to protect it, and they have to comply and do certain steps to do so. So health plans must establish written policies and procedures to protect PHI, protect and safeguard a participant's or covered dependent's personal health information, and that means through on the computer but also on paper. Obtain a participants or covered dependents written permission for certain uses, and again, for a normal administration of the plan, it's not necessary to get, every time you use it, either a dependent's or employee's permission. Notify a participant or covered participant of policies and disclosures and use of PHI. So if you do use PHI, and I'll be indicating that to you, you have to do a notice of privacy practices, and you have to distribute, and you have to give a copy of that to each person who enters your plan, and then 3 years after that, you have to tell them, remind them where they can get a copy. Report any impermissible use and disclosure of PHI, and basically that happens either through fax or email when either you're emailing your broker, your TPA, and all of a sudden you send an email out and you discover that the fax or email went to the wrong person, and that email contained protected health information. And all of a sudden, what do you have to do? And I'll be discussing what do you have to do in order to fix the situation. Over the years, there's been a number of situations where, and it's hit the news, where individuals, for example, put their computer, their laptop in the car was stolen, or the laptop was stolen. Oh my God! In that laptop, there were hundreds, if not thousands, of information about coverage under the employer's health plan, and there are special indications of what happens in regard to that. Under HIPAA privacy, I'll be discussing this. Participants and covered dependents have certain rights and responsibilities. They have a right to come to you and for example, and inspect or copy their PHI. Also, ask you to put certain restrictions on who receives this information. And anytime you release protected health information on participants or dependents, basically anytime you send that information, you have to meet what's called a minimum necessary requirement, which means you only send enough information to fulfill the request. So every time either a provider or a broker or TPA asks for information, and what that minimum necessary requirement means, just give them enough to satisfy their request. And then most important, you must enter into business associate agreements with any vendor who has access to protected health information. That means your broker, your TPA, as I said before, but also it may be your accountant or attorney if they have access to your files. It could be your IT consultant. That could be very important in that situation. So these are things that you'll have to do in order to comply with these requirements. But entering a business associate agreement, basically what that does, those vendors promise to you that they're going to comply with all the rules. So these rules not only apply to your health plan, and that's you'll see the term covered entity. It's your health plan, and these rules create a fiction that the health plan is a separate entity from the employer, and under these HIPAA privacy rules, the entity that enters in any of these agreements is not the employer, but your health plan. So they treat, under these HIPAA privacy rules, they treat those entities as separate entities. So what is protected health information? It's all medical records and other individually identified health information held or disclosed by the health plans in any form, whether communicated electronically, on paper, or orally. So that means if somebody from your HR department is talking about the health claim and they're in the elevator, and they're talking about someone's claim that other people can hear it, that's technically a violation of the rules. So it talks about holding or transmitting PHI is extremely important, and basically only those individuals that work on the plan and the administration of the plan. So what we're talking about is enrollment information, claims information that contains individual names, social security numbers. That's what we're talking about. So health plans may release PHI to employers with authorization in very limited circumstances. And what we're dealing with here is that only those individuals that work for the employer that work on the plan can have access to PHI. So your management team, if they don't work on the health plan, can't have access to it. It means your HR department. It means that your an individual employee's supervisor can go in and look at their records to see, where that person is on their treatment, unless they get the permission of the individual. So here, 3 conditions must be met, and provider must provide service at the request of the employer. Service provided must relate to the medical surveillance, and employer must have a legal requirement under the state law to keep records. So again, in the administration of the plan, all those conditions are met because you have to administer the plan. Now, if you comply with HIPAA privacy and you adopt policies and procedures, a group health plan doesn't need to obtain a participant's or covered dependent's consent to release information for the administration of the plan. So as long as you can have access to PHI, and you can have access to PHI if you adopt these policies, you can actually get enrollment and claims information from your TPA and from your broker for the administration of the plan. But again, it only can be disclosed to those individuals who work on the plan. So plan sponsor's obligation depends on whether it receives protected information, summary information, or no information at all. So as an employer, if you say, I don't want to have access to PHI, what I'm going to do is my health plan is insured, and what I'm going to distribute is the privacy practices of the insurance company. I don't have any information at all about the health plan. I don't want to know anything. If that's the case, you have to be very careful because, again, the only information you can receive is summary health information about what's happening to your plan. you can inquire or have information about individual employees' claims, enrollment. That's the price if you don't want to have access to PHI. So extremely important to understand that. In my experience, as I indicated before, most employers, either on a regular basis and occasional basis, do have access to PHI because they want to know how their health plan is being run. So if you want to have access to PHI, you have to adopt all the policies and procedures. You have to make required plan amendments to your plans to include HIPAA privacy information. So these are the obligations you have to do if you want to receive any protected health information, and most employers do. Now these are some of the documents you have to be dealing with. You have to create a HIPAA privacy policy, which basically outlines exactly how you're going to comply with HIPAA privacy. You're going to have a HIPAA privacy use and disclosures, which indicates how you're going to put that policy into practice. And then you're going to advertise and you're going to communicate your practices by notice of privacy practices, which are given to the participants of the plan. It has to be given out at the time they enroll in the plan. And then every 3 years, you have to tell them the existence. And then if there's any changes to the plan, to your policies, you have to notify them of that fact. Next, if you want to share information with what's called business associates, those individuals who actually service the plan, then you have to enter into business associate contracts or agreements, which basically they promise to comply with the requirements just like you do. So they can be penalized, they may be audited, and so they have to promise that they're going to comply with all the rules. If any time a request for information doesn't come exactly into the administration of the plan, or an individual wants to have access to PHI that the friend or family member that necessarily doesn't have access to it, there's a form called authorization for release of information, where basically you go to the participant or you go to the dependent and say, this person wants your information, can you give your permission? And you get it in writing. So, and that basically indicates what information is going to be shared, when it's going to be shared. And that individual then says, okay, yes, my friend's helping me, and please share that information. And many times, many plans will not share information about family members. And if you have children that are over the age of 18, many plans have a policy that they won't share information even though they're members of your family and they're covered by, as a participant under your plan, under your coverage. Some health plans will not share information. Once that person reaches 18, I'm sorry, we can't share information. Unless you get an authorization from that individual participant or dependent, we won't share information. So again, you have to amend your plan, health plan document to indicate that. You have to put information about the HIPAA privacy policies in your health plan SPD. And then there's another form which is a little bizarre, but the government requires it, where it's called a plan sponsor certification of the health plan. And again, it goes back to the fiction that the government created. The health plan is a separate entity, and that plan sponsor then certifies to the plan that they're going to do everything to meet the HIPAA privacy rules. And it's a document you have in the file. In case of an audit, you show them that the individual plan sponsor has agreed to help the health plan comply with all these rules. Now also, under HIPAA privacy, the individual participants have a number of different individual rights. And these individual rights are then in the privacy practices, but also in the notice. And individual participants have a right to request inspection of a copy of PHI, request a copy of correct PHI, request for an accounting and disclosure of PHI, where they ask the health plan who did you disclose my information to? And then they have a right to request restrictions on use and disclosure of PHI by saying, and a good example of that, don't send claims information to my house, send it to me here, or send it to another address. And a participant can request that from the plan, so they can do that. So again, as long as you comply with HIPAA privacy, you can, again, health plans are allowed to use and disclose PHI for the following circumstances. As required in accordance with the individual right to access PHI, for covered functions to administer the plan for treatment, payment, or health plan operations, for enrollment and payment of claims, with respect to specific types of information about the opportunity to agree and object. What does that mean? Somebody calls you up, an employee calls you up, and they have a question about a claim they filed. And on the phone with them is a friend. As long as that friend is on the phone with the employee and that employee doesn't object, you can share information with the friend. But if that friend calls back an hour or two later with the individual employee not on the line, you need a individual authorization. So if the employee is there with their friend, you can share information to. But again, you have to be very careful when you share PHI, especially with claims information, with individuals other than the individual themselves, the participant. Also, there's other situations where you may have to share information for public policy reasons. In case of a divorce or a domestic abuse or for example, flu epidemic, you may be contacted by the local health department about information about how many people at your shop have the flu. So, I mean, in situations, and I'll be discussing that, you're permitted and many times required to share that information for public policy reasons. So again, a health plan may use and disclose without authorization for its own treatment, payment, or health plan operations, but again, only if you complied and created these policies and procedures. For treatment activities for another health care provider, to another covered entity for payment activities of an entity receiving the information, which means either a TPA or an insurance company. You can, again, go back and forth and exchange information. To another covered entity for certain health care operations activities of the entity that received the information, if each entity has a relationship with the individual that is subject. Again, these are providers, hospitals, TPAs that are, again, disclosing information back and forth in regard to claims. A health plan may use and disclose PHI if the individual has the opportunity to prohibit the disclosure of such information in advance regarding to disclosures of limited type of information. And again, I described with a personal friend on the line, uses and disclosures of limited types of information for facility directory purposes. Individual authorizations are required whenever the use and disclosure is not permitted under the privacy rules. And what I indicate is the fact that when in doubt, when you're not sure, you want to disclose it to an individual or to an entity and you're not sure, it's always good policy to say, wait a minute, before I disclose information, let me get our individual authorization from that employee or dependent to make sure I'm doing this right. So again, unless it comes under one of the exceptions where you don't need an authorization, it's always important to get an authorization to protect yourself. So again, health plans may disclose PHI if required by law to certain designated public entities, individuals, and the employer, and again, only certain individuals of the employer. Regarding an individual, if a victim of a designated abuse and certain other conditions, the health oversight agency, in response to certain court proceedings. Again, you may be subpoenaed, especially in a divorce situation or a criminal case where you may be asked to supply information to law enforcement officers of certain conditions. And again, it's extremely important. If that is the case, you have to be sure the person on the other line requesting that is actually a police officer. To a coroner or a medical examiner for ID purposes, to an organ procurement organization for transplant purposes, to prevent health threat, again, flu epidemic or other epidemics that may come in the future, for certain specified governmental purposes, and to comply with worker comp purposes. Now, one thing that's important is, and this is what confuses a lot of people, is that what we're talking about is protected health information that is being held by the health plan, the dental plan, and the vision plan. Any other health information that's held by the employer in the employment records is not protected by these rules. So we're talking about in regard to workers' comp, certain disability claims are not protected by this. So please understand this. This only affects any information held by the health plan. If there's any health information contained in the employer's employment records, it's not being protected by these rules. So again, permitted uses for health underwriting and placement of health insurance is permittable. Sharing PHI with other covered entities for other purposes are limited, and again, it's for the placement of coverage. It could be for, again, a TPA determining the claims. Could be for a stop-loss carrier if you're self-insured. If it goes beyond that, again, authorizations may be necessary. Also, too, personal representatives, minors, and spouses. Remember, if somebody is acting on behalf of the individual, you have to get their authorization. And there has to be, for example, a power of attorney if someone is acting on their behalf. But many times you'll get this if somebody's in the hospital and the family member or a friend is working in their behalf. Before you can release any information to the family member, to a friend, you have to get an authorization or power of attorney from that individual to make sure you can share information. Now, parents' authority. This creates a big problem once that minor reaches 18. In that situation, most health plans will not share, as I indicated before, health information about that minor who's just reached 18, and you have to communicate your policy to the employees about who you will share information with. So again, if a child is under age 18, generally you can get information about that child, but once they reach 18, you have to get an authorization. Some health plans, for example, won't share information about your spouse. Again, it's dependent on what your policy is, and you may indicate, well, in your policy, every family member can share information with other family members. If you object to that, tell us and we won't share it. So there's two ways of dealing with this. You don't share any information with other family members, or you do, and if you don't want to, you tell us to withhold that information. So there's two ways of dealing with this. But you have to communicate that in your privacy policies and put that in there, so if an employee doesn't want information to be shared, they have to come to you and say, I'm sorry, don't share my information with my spouse. So again, health plans must establish policies and procedures with respect to PHI, and in there, in your policy procedures, it indicates how you're going to comply with HIPAA standards, how you're going to protect PHI, how you're going to implement those standards, and then again, how you're going to protect employees and give them the individual rights to access PHI. So many times these policy procedures are 10 or 15 pages to go into detail about what has to be included in these rules. But those are the three major steps you have to cover in your policies and procedures. Now, in also a requirement is the privacy notices. Once you have your policy practices in place, you have to communicate that, and again, who's responsible would be the covered entity or the health plan or in essence, the employer. So if you want to have access to PHI, you have to come up with a privacy notice that you give to the employees. And what must these notices describe? You describe to the employees how you're going to use and disclose PHI. And basically what it indicates is the fact that you're going to disclose PHI to a third-party administrator, to the insurance company, to the administration of the plan. You go into detail about what you're going to do. Then you inform the participants of what their individual rights are and how they can access PHI. They can get accounting of PHI, all the individual rights. And then you're going to go into detail in the notice about the health plan's legal duties in respect to PHI. How are you going to protect that information? There's going to be certain standards, both electronic and other things you're going to do to protect PHI. So you can describe that to the employees so they make sure they understand how the information is being protected. And again, this is important because if you're going to be audited by the Center for Civil Rights as part of HHS, they're going to ask for all these documentation. And so you have to have it in your file, and you have to basically communicate that to the employees and show that you've actually distributed to the employees. So what are the health plan's duties? Well, again, they have to distribute their own privacy notices that they have access to PHI. So what may be confusing to the employees, if you want to have access to PHI, is you may have to, again, you may have to distribute the notices of the insurance company and then your individual notices of what you're going to do, which could be very confusing to the employees. Now you could have, again, the TPA distribute that, especially with the enrollment information. That's the easiest way that most employers do that as part of the packet. Now, what is required under the privacy rules that you have to appoint a privacy officer and security officer that will oversee and make sure everything is being done. So a privacy officer is responsible for the development and implementation of policies and procedures. And you can have one privacy officer or several, depending on how your company is organized. If you have subsidiaries, you may have one privacy officer. And these are individuals that are advertising the privacy practices that they are responsible for that. And this is important, I think. And also, what many companies do, they have a privacy officer, but they may also, especially if you have different locations, contact person they can go to at their local office if they have complaints, if they see, for example, certain things going on, discussions in the hallway or in the cafeteria that could be violating HIPAA privacy. So such designation has to be documented in the notice of privacy practices, and the contact person must be able to provide additional information about matters that are covered under the privacy notice. So again, they must be familiar with the practices. Does the plan share information about PHI to family members? What protections do you have in making sure my information is protected? Things like that, questions. Also, what's very important, you have to demonstrate healthcare security requirements, because in most situations, that information is no longer being stored in paper, but electronically. And what HIPAA privacy does is there's certain healthcare security requirements. These requirements apply to electronic storage and transmission of PHI. They've been effective for over 10 years. And covered entities must implement appropriate administrative, technical, and physical safeguards. And if you get it audited by, again, HHS, you're going to have to demonstrate that you've actually tested these, so your IT department is extremely important to make sure that you've actually implemented appropriate administrative, technical, and physical safeguards for PHI. So again, privacy rules require appropriate safeguards to protect PHI, and you have to demonstrate and test them on a periodic basis to make sure. Now, this information only applies to electronic PHI. And basically what these rules say, anything is protected health information, if it's transmitted in an email, one thing these rules require is that that email must be encrypted. If it contains PHI, it cannot be sent over the internet without being encrypted. Because once it goes on the internet, you don't know who can intercept it. So again, anytime you're sending PHI to your broker, to the third-party administrator, to the insurance company, it's got to be encrypted, because basically what HHS says is that if it's not being encrypted, it's unprotected. It's not a secure transmission. Extremely important. Now, again, this only applies to anything is considered electronic, and faxes are not considered electronic unless it's sent over the computer. But again, anything, any transmission or storage of PHI has to be protected, and if you're transmitting PHI, it has to be encrypted. So what are the 4 security requirements? Basically, you have to make sure, and I'll be covering that in the next few minutes, you have to ensure confidentiality, integrity, and availability of all electronic PHI for the covered entity that creates and receives and maintains and transmits PHI. You must protect against reasonably anticipated threats and hazards, which means firewalls, and your IT, I have a checklist that I can send you that goes through all the different requirements, but this has to be demonstrated on a pretty frequent basis. So you must protect against any reasonable anticipated uses or disclosures of such information that are not permitted or required. And again, with all the hacking going on right now, this is extremely important. And what you must do is make sure that you ensure the compliance of your workforce of all these requirements. So without the security requirements, you have to basically demonstrate you meet the administrative safeguards, physical safeguards, and technical safeguards of any electronic PHI that's in your system. And it could be, for example, on computers, if somebody in the HR department is working on information on their computer PHI and they leave, is your computer systems secure enough that it will go off after so many minutes? Are the screens of the computers pointed away from the general people walking in? So that's basically what so covered entities must demonstrate they use reasonable and appropriate measures to accomplish these requirements. And basically, in order to comply with these requirements, you have to engage in a risk analysis to determine how to comply. So all covered entities must use standardized format and content for all electronic transmissions, and we're dealing with, again, emails. These are called the EDI standards. Covered entities in conducting covered transactions must use standardized formats and content as well as uniform codes in communicating with other entities. Only those entities that conduct standard transactions electronically or engage in others are subject to these requirements. And health plans are considered to be covered entities and must comply with these standards. These are the covered transactions that are covered by this. And if you look through those, this is basically covers every aspect of the administration of a health plan. It includes health claims and equivalent and counter information, health care payment and remittance, coordination of benefits, health claim status, enrollment and disenrollment in health plan, eligibility for health plans, health plan premium payments, referral certification authorization, first report of injury, and health claims attachments. So all this has to comply with the security requirements. So what transactions and transmissions are covered? And again, this involves any transaction that's electronic, which means any emails. So any aspect of the administration of the plan are covered by these electronic transaction requirements. So covered health plans must comply with these standards. So again, EDI standards apply to transmissions transmitted using electronic media. It doesn't apply to anything contacted in paper or telephone. It doesn't apply to any uncovered entities. It doesn't apply to group health plans under 50, and does not apply to health plan sponsors because they are not covered entities. But again, in most situations, the health plan and the employer are one and the same. Now again, one troublesome part you have to be very careful with is that group health plan may not share PHI with the plan sponsor except for the disclosure of de-identified information, group health plan enrollment or disenrollment, limited summary information for insurance placement and settled function, PHI to the plan sponsor of personnel involved in plan administration, and when in doubt, it can only be shared with pursuant to an authorization. In layman's language, what that means is if your HR department is administering your health benefits, your health, your dental, and vision, that information has to be kept inside the HR department. And you have to advertise the fact that these people have access to PHI. If your finance director or your CEO wants to get information about this, technically you have to get an authorization. This becomes extremely important in regard to instituting a wellness program. You have to be very careful about what information can be shared with the management of your company. And as long as identifiers, the names, social security numbers, addresses are taken off, there's no problem. But again, if it's protected health information, it cannot be shared with the general population of the employer. So health plans cannot provide access to PHI to plan sponsors without certain plan provisions and safeguards. Disclosure must be for plan administrative function, again, only for those who work with the plan. Healthcare providers and health plans must use and disclose PHI with individual authorization for any purpose provided in the authorization. And these functions include plan must not condition treatment or payment on the receipt of authorization. In some situations, an author may not condition employment on an authorization. Authorization may be required for certain PHI for purposes of family and medical leave and ADA, because remember, in that situation, health information for the health plan is being used. An authorization may be required for the employer to assist the employee claim. An authorization may be required for the employer to receive reports on the EAP. And again, it all depends whether you've adopted all these HIPAA privacy policies and procedures. And again, I just want to emphasize, and I said this a few minutes ago, but it's true. Remember, we're only talking about health information that's being held by the health plan. If an employee's health information is in his employment records, and it's not dealing with health coverage, that information, again, is not protected. So we're not talking about workers' comp, and any other health information that's in his employment record is technically not protected. Now, some special concerns here, and again, you have to make sure you change office behavior. You can't talk about claims or enrollment and the company cafeteria or lunchroom. Shred pertinent documents especially, do not simply discard them, especially if they have social security numbers or individual name. Prohibit a staff from accessing a participant's medical records to learn a neighbor's birthday or to satisfy similar curiosity. Those records should be, again, if you keep in paper, should be in locked drawers. Do not leave messages about a participant's health on an answering machine or with someone other than a patient or doctor. Avoid discussions about a participant's claims in elevators, cafeteria plan, or other public places. This is more of a doctor's office type of thing. Avoid paging participants using identified information. Do not fax information without knowing the person to whom the fax is being addressed to is ready to remove it. And do not allow faxes to sit in the office machine where unauthorized people may see them. And especially if you're faxing something to a large organization, always make sure you have a cover sheet and make sure that the individual receiving it knows it's coming. Amanda, do we have any questions?
Right now we just have one. I see TV commercials for type 2 diabetes, and the interviewer asks the person in the commercial if they have type 2 diabetes, and the person answers yes. Can this be asked on a TV commercial, or does it violate HIPAA laws?
Well, again, if that person answers, but you cannot, again, ask that person, if it's for the administration of the plan and it's somebody in the HR department, yes. But again, you have to be very careful if you're a supervisor of an employee and you're asking questions about their health. That's a violation of HIPAA privacy.
All right, and that's all.
So if it's in the relation for the administration of the plan, it's involving their claim under the plan, yes, it's possible. But any other situation, no. Okay? Let's go on, and this is something that happens to almost to every employer, every business associate, anybody dealing with a health plan. An individual is going to make a mistake, and what they're going to do, they're going to send faxes or emails to the wrong person. If that's the situation, and it's going to happen, that's considered a security breach. And depending on the situation, you may have to notify the individual involved, HHS, and you may have to advertise it to the world that you made a mistake. Let's look at this, and there's certain requirements that an employer, a health plan, and a business associate have to take if it's discovered there's a security breach. Extremely important. And the security breach is basically information is going to the wrong person. And again, this is very common. Many times I send emails, and every once in a while I send it to the wrong person. You have to be extra careful if that email that you're sending contains PHI. So the American Recovery and Reinvestment Act in 2009 modified HIPAA, and there's new security and privacy rules, created new notification rules for a privacy breach. You have to notify the affected individuals, the media, and in some situations, HHS, and there's penalties for non-compliance. So, and again, this applies, and this slide is extremely important. It applies also to your brokers, your TPAs, any business associate that has PHI that is sending to you and they make a mistake. All these rules apply, and they have to notify you when they make a mistake. So a breach is the acquisition, access, and use of disclosure of PHI in a manner that is not authorized, permitted under HIPAA, which compromises security and privacy of the PHI, and regulations do not incorporate the statute's use, access, maintains. Basically, you're sending information to the wrong person. Information, and again, we're dealing with PHI. If information contains person's name or social security number, their condition, what the treatment was. So it compromises is defined as a breach that imposes significant risk of financial and other harm. And you have to make a judgment of that. And you have to make a risk assessment about, should be done and documented, about whether a breach notice has to be provided. Now, during this evaluation, consider who impermissibly used a PHI and to whom the information was impermissibly disclosed, and the nature of the PHI that was disclosed. If the name of the individual and the plan participation were disclosed, there could be a privacy breach, but where's the harm? If the type of treatment or other sensitive information are revealed, then there's a higher risk of harm. So again, depending on information contained in that email or that fax is going to be very important. So again, this has been in effect since 2010, and there are certain exceptions to these rules. If you have a secured PHI, for example, if you send an encrypted email, but you sent that email, that encrypted email, to the wrong party, they can't open it. There's no breach. No problem. Unintentional acquisition, access to use by an individual acting on the authority of the BA. So you send the information to the broker, and you're supposed to send employee A, but you send employee B. There's no problem because that BA, that business associate, has a responsibility. Inadvertent disclosure from one covered entity to another. Again, you send information to the healthcare provider, but you send it to the dental provider, no problem, because they have, again, a responsibility to keep that information secret. Unauthorized disclosure with the unauthorized individual who would not reasonably have been able to retain the information. A situation where, for example, you send a information through the mail, and that information was supposed to go to employee A, went to employee B, but B moved, and so that information was then returned to you. Again, nobody looked at it, there's no problem, and therefore no breach. So a secured PHI is any electronic data that's encrypted, any paper that's shredded, and any electronic purge in accordance with specific standards. Unsecured PHI is not rendered unusable, unreadable, or indecipherable to an unauthorized individual through technology. So if you send an email through the internet, again, that internet is not protected, it's considered to be unsecured PHI. So again, safe harbor in motion and rest or use. If it's encrypted, it's considered to be protected. Exception 2, unintentional acquisition. An employee who's responsible for billing receives an email which contains PHI about a plan participant from another employee. The email is accidentally sent. The billing employee opens the email, notices that she's not the intended recipient, alerts the employee who sent the email, and then deletes it, doesn't look at it. In that situation, it's another workforce member, and therefore there's no problem. Another exception is disclosure to another covered entity. A member of an appeals committee shares a participant's PHI with another committee member. Member 1 thought the participant had appealed the claim, however, it was actually a different participant's appeal. Member 2 does not disclose PHI. So again, it depends on who you send it to. Disclosure of PHI where it was not retained. A plan mails a number of EOBs to the wrong individual. The EOBs are returned by the post office as undeliverable. There's no disclosure, no problem. So again, the plan and any business associate must determine whether there was impermissible use and disclosure of PHI, whether the impermissible use and disclosure compromised the security and privacy, and you have to determine before you determine as a breach if any exception does apply. Now, if no exception applies and the breach has been discovered, then the business associate or the covered entity should report the data to the plan within the time frame allowed by the agreement, by your BA agreement. A plan must notify each individual whose unsecured PHI has been or is reasonably believed to have been accessed, acquired, or used. In some situations, you may have to notify the media, and in some situations, you may have to notify HHS. So again, when is the discovery of the breach, and this is important, the first day in which the breach is known or should have reasonably been known. That's when the time starts ticking. The plan and BA is deemed to have knowledge of workforces and other agents. And again, it's extremely important what a reasonable person have discovered it. If a breaching employee never tells anyone of the breach, the breaching occurred but cannot be discovered, and therefore there's no reporting obligation. This is on reporting obligation. So again, the business associate must notify the plan. BA must notify the plan within 60 days. Many contracts, even shorter periods. It could be 15 or 20 days. And the BA must provide a list of each individual whose PHI was breached. When you notify employees, the plan must notify each individual whose unsecured PHI has been or is reasonably believed to have been accessed, acquired, or disclosed. And you must notify, must be made without reasonable delay, but no later than 60 days after the discovery. When direct notice is not permissible, the plan has insignificant or out-of-date information. For less than 10 employees, a telephone message. For more than 10 employees, a posting on the website is also allowable. So again, notification is extremely important. And this notice must contain plan language, brief description of what happened, the type of unsecured involved, steps individuals should take to protect themselves, brief description of what is being done to remedy the situation, mitigate it, and contact procedures for individuals to ask questions. Now, this is a very rare occasion, but it happens every so often. When must the media be notified? Notice must be provided to prominent media outlets, which means newspapers in the state or in jurisdiction if unsecured PHI of more than 500 residents of the state or jurisdiction believed to be accessed, acquired, or that happens if a laptop is stolen and contains a major. So again, that's a pretty high bar. So very rare occasions, but it does happen. HHS has to be notified. Notice must be provided to HHS if there's a breach of 500 or more individuals. You have to notify them immediately. If it's less than 500, must be submitted within 60 days after the end of the calendar year. So again, very rare occasions, but again, if there's a breach, if it's less than 500, you still have to notify HHS. State notification rules are not preempted. Other states have various rules. Penalties and enforcement. This is extremely important. Penalties amounts. Minimum of $100 if you did not know the violation and would have not known, even with reasonable diligence, with a maximum of $50,000. Minimum of $1,000 if reasonable cause and not willful neglect. $50,000 per violation. Minimum of $10,000 if willful neglect but not corrected. Maximum $50,000 per violation, 1.5 million in total. And if there's willful neglect and not corrected, it's $50,000 minimum up to 1.5 million. All right, as I indicated before, in March of 2016, the Center for Civil Rights, which is the division of HHS, is now conducting what's called Phase 2 audits. Who is being audited? They are intended to audit a wide range of covered entities, which is, again, and business associates will be added to the list. All right. And their goal is to have a broad sample of audited entities, including each type of covered entity, plans, providers, clearinghouses, different types of business associates, could be brokers. So, I mean, you could get in the back door in regard to this. What is the structure of the audit program? Round one would be remote desk audits of covered entities, which means either a phone call or an email. The second round, it will be remote desk audits of business associates based on documents and other information received in response to information requests. The third round would be, again, on-site audits, where they come to your office and look at your documents. Now, this is important. How will the audit program work? Entities selected for audit will be sent an email notification of their selection and will be asked to provide documentation or other data. They're going to have 10 days to answer the request. After receiving the relevant documentation, other information, auditors will develop and share draft findings with the audited entity. The audited entities will have an opportunity to respond to draft findings and then written responses to be included in the final audit report. What is the timeline? Again, once the auditor sends draft findings to the audited entity, the audited entity will have 10 days to review the findings and return written comments. So again, it's very tight response times. The auditor will complete the final report within 30 days. And the audit and the on-site audits will be conducted in a 3 to 5 day period. They'll be sitting in the office for 5 days. As with this audits, the audits will just have 10 business days to review and submit written comments to the draft findings. So again, not a lot of time, so you should be prepared for this. So what is the likely scope of an audit? They will indicate that this audits would be more limited than on-site audits and release an updated audit protocol. So under this protocol, what is the likely scope of the audit? The protocol is, and what they're asking for it, is a copy of a notice of privacy practices, the right to request privacy protection, access to individuals to PHI, administrative requirements such as training, policies, procedures, use and disclosure to PHI, and then individuals' rights to request amendments to PHI and accounting of disclosures. Most employers couldn't comply with this requirement. They don't have these documentation in place. And yet, remember, once you get a request, you have 10 days to respond to the Office of Civil Rights. How do you prepare for the possible audit? Be alert in communications. Again, you're going to get an email. Don't ignore them. Round up all the inquiries. Have an audit response in place. First of all, conduct a pre-audit review. And once you get an audit, remember, time of the essence. You may have 10 or 15 days to respond. And again, know your business associates. Make sure you have business associate agreements in place in all your vendors. And make sure you develop and update compliance documents. All right. Are there any questions?
Yep, we have a couple. The first would be, do you have any recommendations for encryption software for small brokers?
There's a number of companies out there that have encrypted. I don't have one in particular. I use one company. If you want to email me, I'll give them their name. But there are a number of encryption companies out there. I don't want to recommend one over another.
And then,
but that's one of the big violations. That's one of the big violations that people have discovered. Oops, I'm sending PHI without being encrypted.
And then the other question was, did slide 24 show that EDI privacy regulations do not apply to small groups?
Yes. 50.
And then, is there such a position as an audit response specialist?
I don't understand your question.
I think they're wondering if it's possible to hire somebody who would be an audit response specialist.
Oh, probably look on the web, because this has been going on for, again, over a year. And if you go on the web, and I think there's a number of companies that can assist you. I've assisted employers on this, so I mean, there's a number of people that can do it for you.
All right. Okay, and then Larry, if you could just click next for me. I want to be respectful of your time. I know that we're a bit over, but I just wanted to tell you a little bit about benefitexpress. We help our participants understand and use their benefits wisely so they can be accountable for their health care, and we enable you as the plan sponsor to enable and deliver your benefits strategy. We provide a whole host of services that we have along the side, and if you have any questions, oh Larry, could you click next? So here's a little bit about our numbers, our clients. We work with everybody up from 1,000 clients to 10,000 or more clients, and we have a whole host of different solutions from both our Schaumburg and Rancho Cordova offices. Next. Here is some of our partners. We work with Optum, Unum, Summit HR and Payroll, along with a whole bunch of other integrations to provide the best, most seamless service. Next. And you can contact sales@mybenefitexpress.com if you have any questions. We'd be happy to show you our system. With that,
and here's my contact. Yeah, here's my contact information in case anybody has any questions.
Thanks. If you have any other questions, please feel free to type them below. We'll be on for a couple more minutes. Other than that, thank you guys so much, and I hope you have a great day.
Thank you.